Hello, my name is Jeffrey Smith. I'm an attorney with the Orlando Law Group, and this is the Orlando Law Group's discussion hour over family law. All right, here to my left, I have my colleague, Marsha Summersill.
Hello, my name is Marsha Summersill. I am a family law attorney. I'm also a certified mediator and a guardian ad litem with domestic relations. So we're going to share all kinds of information today.
We are. So, Marsha, when a client comes in to talk to you about a divorce, what are some of the common issues or questions they ask you?
Well, the funny thing is, when people come in, we always do what we call the initials of peace, believe it or not, in the divorce process. So the big issues that we have to address are obviously parenting plan, alimony, equitable distribution, child support, and each case has an individual nuance. Then we start going into everything else that's going to be specific to that case. So we definitely have a lot of things to address in the divorce process.
Okay. So what happens when the client comes in? Like commonly what I will get is these accounts are in my name, those accounts are in his name. How do you kind of tie that all together and advise the client on what's marital property, what's not marital property, what's his, what's hers?
Well, in the consultation process, it's a little difficult for us to be well-versed on exactly what's going to be classified as marital or non-marital. So what we try to do is get them to do an intake form so we can get a preliminary idea of what assets that are going to be split, what assets that might be argued, whether or not it's marital, premarital, or non-marital. Those are those three classifications. And then how to get those items split among the parties. You don't necessarily have to split each individual piece 50%. We look at the overall value of the estate to determine if we can just get them both 50% of that value.
Right.
So it's
so equitable doesn't mean equal, or equitable doesn't mean 50%
of individual accounts.
Correct.
Now,
okay.
It's supposed to be, now everything is a nuance, right? It's supposed to be 50% of the actual marital estate. Some arguments can be made that one party gets a little bit more than 50%. Now, the other thing that most people forget to discuss is debt. So we've actually had cases come in where they have a lifestyle, but it appears there may be some assets to split. But once we dig into that, unfortunately, we see that we're going to have what we call a debt case, where we have to figure out which spouse is going to have to take at least 50%, and in some situations, not necessarily equal, depending on the behavior of one of the spouses, to determine if we're going to do more allocation of a debt on one side over the other. Okay.
So how do you react when like I commonly get when people come in and they have children? I want sole custody. I want 100% custody. How do you address that with them? Because we know there's been some statutory changes in July of 2023 regarding time sharing.
Yeah.
So how do you kind of guide the client when they come in and they're absolutely adamant that they want 100% time sharing and the other parent shouldn't even see them at all?
That's what I call a better parent syndrome. There's very few situations where it's appropriate, in my opinion, to not allow a parent to have at least 50% of the time so they can try to see the child as frequently as possible and build and maintain a relationship with their children. So I'm not easily persuaded that one parent should have majority time, sole care and custody, or anything of that nature. It's going to take a lot of issues for me to feel that that's an appropriate direction to go. Now, the statute that got passed in July of 2023, I think has a good baseline. Now, there's a lot of people who are not comfortable with it in the legal field, family law world, the mental health world, I think that there is this mindset that there is sometimes, not all the time, one parent who is like that stay-at-home parent. Traditionally, it's the mom, not all the time. And that person has that rapport and the routine and all the things set for the child, the school designation. There's all kinds of things that we have to consider. However, I'm also someone who's worked in child development pretty extensively. So I personally will encourage my clients, when appropriate, that equal time sharing is probably the best bet to go, to relinquish what I feel they have this sense of entitlement that because I was the person who did this, therefore I should be the person to have majority time. I think we just have to really adjust that, listen, you're no longer a single family unit, and that child has the right to have a relationship with both parents. Right. So I think it's imperative that we educate our clients that this is a realistic approach. Not necessarily everyone is going to have 50-50. Jobs will impact that. Obviously, airline pilot's not going to be home enough to have that kind of type of time sharing. However, I think it's really important to preserve the relationship with both parents.
So it's very factually specific between each party themselves. Yeah. So when you have that client that comes in and says, well, my friend's divorce, this happened, or I read on the internet about this divorce, it doesn't necessarily mean it's going to be the same for that person. Is that your
Google, right?
Correct.
Lawyer Google. I Googled it.
Right. So how do you handle a situation where the client comes in and there's children involved, and your client is sitting there and they're saying, I'm leaving. What should I do to protect myself? And when I say leaving, I mean moving out of the house. They're not going out of state. They're just, I'm renting because we cannot cohabitate together anymore. Are there any recommendations, or how do you advise a client when one spouse wants to leave the house? Mm-hmm. And there are children involved. So sometimes that spouse may want to take the children, sometimes they may not. How do you advise them in that for things to do?
Like during the divorce process?
Well, even prior to the divorce. So for example, what I do in that situation is I tell the client, if they're going to leave, be sure to document, take pictures, videos of everything in the house, the outside of the house. I commonly also advise them, if they're going to move and take the children, don't go out of the school district. Situations like that, even accounts. As attorneys, we cannot control what our clients do. We can advise just like doctors, but getting them to take the medicine doesn't always work out. So commonly, even when a client is leaving, I'll say, look, take what you think is yours. Don't get rid of it. Put it in storage. Put it somewhere. Because oftentimes, from my experience with clients, when they leave the home and they go get their apartment and everything's set up, many times they've not taken anything. They've taken a small suitcase, then items start going missing, items start getting sold, and sometimes it can be very difficult to track that. It encourages litigation because now we've got to do discovery to find out what was sold to whom, when, for how much, to ensure we get our share. Is there any particular advice you give to your clients when they say, hey, Marsha, I'm moving out next week. He doesn't know yet. He's just going to, or she, they're just going to come home. I'm going to be gone. What do you recommend?
Well, the first thing I do when I have my consults, like if we haven't filed for the divorce yet, or if they haven't decided on an attorney, I do always ask, is there a safety concern? Obviously, not necessarily does it need to rise up to the level of domestic violence, but when you have emotions of this nature involved, there's escalated arguments, there's sometimes threats that are made. So sometimes it is in the best interest of one spouse to exit the cohabitation type of environment. So I do agree with you. I think that taking photographs, taking kind of an inventory of things, particularly if there's anything of substantial value, that are going to leave in the other spouse's care until you guys decide how you're going to divide all that stuff up. Because what happens, that comes back in. If something is sold, we may not be able to get that cash back, but that value is going to be included in that equitable distribution worksheet, just to make sure it's recaptured for the other spouse.
Right. Right. And for clients, that's important because what they have to understand is when we do all this balancing, there's usually an equalization payment.
Correct.
And that's where that is most effective, is down there, because when we speak to a client and we say, it's equitable, meaning, it may not be 50-50, but it's all supposed to balance out in the end. It never balances out in the end.
Yeah.
There's always one party getting a little bit more, a little bit less than the other. And the way that's addressed, as you know, is through an equalization of payment. But we've got to document that. We've got to produce evidence to show this is why this party is getting a little bit more or less than the other and owes that party, that money. And for what? For what asset was it? Correct?
Very true. I think the other concern is when you go through the divorce process, I'm always cautious when one party is responsible for paying the other party what we call an equalizing payment. Most cases, not all, there's not enough cash for do a lump sum. So having something sitting out there where that one spouse, in order to be equalized, is waiting for the other spouse to pay them, or ex-spouse at this time, it's a little precarious. The enforcement, I prefer, the phrase I use is there's not a lot of teeth behind equitable distribution. Now, alimony and child support, there's some significant contempt stuff there. But when it comes to property, it's best, when at all possible, if there is an asset that can help that offset issue, I prefer that my clients get that asset as opposed to waiting for some type of payment from the spouse who owes to equalize that kind of stuff. But it's, equitable distribution, lawyers aren't mathematicians. We are the worst math people out there. So for us to try to figure stuff out is not the best situation. Right. We do bring in accountants when necessary. That's not necessary in most divorces. But we also have spreadsheets, and certain jurisdictions in the state of Florida will have one for us that we're required to fill out. It helps us make sure that our math is correct because we don't want to make mistakes like that. So it's something that can always be explored. I always encourage people to be unique to your circumstance. You don't have, the more you go in front of a judge, the more narrow and more boundaries are in place with you can and cannot do. Mm-hmm. So being creative with these assets, or being creative, especially if it's an income-based asset or if it's something that's accruing some type of positive interest. I even if my client gets a little bit less, but I know that it's producing a pretty substantial interest rate, I'm like, let's get that. Right. Because within 6 months to 1 year after the divorce, you could increase your assets and your wealth because we got that particular income or asset producing item. Right. So we always look at things in the long run too. Not necessarily, there are situations where they need that cash up front, but the reality is if it's not necessary for the cash up front, let's look at the ongoing long-term benefit. If you're getting this retirement account, this stock account, or this rental property, that instead of having cash
appreciable assets that are going to grow over time.
Yeah.
So you touched on child support and alimony. And I have, I don't say frequently, but I have a large percentage of clients that do come in and the first thing out of their mouth with the kids is we agree on everything and we waive child support. We're just going to work out time sharing 50-50. We don't either one pays the other child support. How do you address that with your clients?
Child support cannot be waived. We do have that conversation. But I do have situations where there isn't a huge disparity in income. Or I have situations, especially uncontested, where one spouse is taking on pretty substantial expenses for the kids, usually private school, daycare. They may be prodigy gymnasts, and we know how much it is to go on the circuit for gymnastics, or baseball players. I've had one client whose daughter was a ballerina who actually ended up getting accepted into these very prestigious schools. And then the father was responsible, agreed to maintain those type of expenses. So I think that when it's an uncontested situation, it's appropriate to incorporate those types of things. However, if it's contested, the judge is going to let you know, that's great of you, good job, but these are the formulas that we have to use.
Right. Now, part of that formula, as you know, involves payment for daycare.
Yes.
Correct? What is your particular take on, should we include daycare in the calculation, or should we have the person make payments directly to the daycare provider? Okay,
this is a hot one now, and you're probably going to be a little different. Now, I personally, when I represent the client that makes a little bit more money, and they end up being the payor of some type of support, I recommend to them that they pay the daycare, that they don't get some kind of 50-50 credit for it, because there's always that one spouse who never pays their half, and you end up paying 100% of the daycare, and you end up accruing more cost. And it's just not beneficial. That's my take on that. Daycare should be included because that's part of the cost of raising a child. Most of us have to work. And what I don't like is when we have the income producing parent punished because they have to put the kids in daycare because they work. That income producing parent is still most likely maintaining some type of lifestyle to the other spouse or the other parent who doesn't have that type of income. So they're supplementing them, whether it's through alimony, whether it's through child support. So I absolutely think it's imperative that those type of costs are included with that assessment.
Okay, and how do you respond? And most clients won't think of this, but how do you respond when the client has, say, a 3 and a 5-year-old, and we put daycare into their child support calculation, and they're 10, 12, no longer in daycare, but still paying those costs?
Well, most of us, if you go in front of a judge, most likely you're not going to get this. This is why we encourage agreements.
Correct.
Most of us, when we do agreements, we have a provision in there that says in 3 years, we agree to recalculate support. You don't necessarily want to have future agreements on changing time sharing. Those most likely will not be enforced. However, incomes change, and you want to save money by not having to file a modification, which can be pricey.
Right, very.
So having these in the actual final judgment, not just in the agreements, the parties agree. They're going to reassess in 2 to 3 years in order to make sure that it's equal as far as the child support piece of it.
Okay. Moving on to the second part of support. So understand in Florida, in terms of support, we have child support and alimony, which is commonly referred to as spousal support. Finally, in 2023, we got at least a formula to guide us. So for those people out there that think alimony may be a part of their case, it may not, how do you evaluate just from an initial, this is our first consult type scenario, he makes more than me or she makes more than me, she should pay me alimony. How do you handle that and advise your clients on a very general aspect? Because I'm sure you know, part of the divorce process involves what's called mandatory disclosure, which is required, particularly if we have children. Well, part of that also comes into play in doing an alimony evaluation, which is based off need and then ability to pay, and then we apply the statutory formula.
Right.
So how do you address your clients when they're, I want alimony?
Yeah, everybody wants alimony. I would say that and here's my little caveat I'm going to put onto that. Of course, the basic is the length of the marriage. We do have, kind of a new way to look at that, whether it's short-term, long-term, or intermediate. You also look at the ability to pay. If there's no money, if there's someone as a W-2 and they're barely getting by at $50,000 a year, it's highly unlikely or appropriate, I'll put it that way, for alimony to be awarded, because we have to go off the net of those individuals. And if you can't pay your bills, how the heck are you supposed to be paying somebody money? So I think my personal issue is, now that we don't have this as a factor, and you know this, but I'd like to get your opinion, is inflation. I literally had a case where I was shocked that my client ended up being ordered to pay alimony, and it was such a struggle for the judge to determine how is this appropriate. Now, they were so fixated on the length of the marriage that they absolutely did not look at the issues that we're facing as far as inflation. So is it realistic for somebody who made $90,000 to be responsible for $1,000 a month to a spouse and still not have enough money to pay their own bills? Because $90,000 doesn't do much anymore. No,
not at all. And I believe it is in the statute, or maybe at least in case law, that we cannot leave one client with much less income because they're paying the other client.
Right.
And the difficult thing with inflation is we never know how that's going to roll out. We never know how it's going to be controlled. So that could, if that is entertained, could open the door to essentially continuous alimony reevaluations, because we can't just look at inflation. If we're going to go 15 years down the road, or 10 years or 5 years, either way, and adjust for inflation, we really should adjust for the overall financial position of the parties at that time, their overall picture. Did the need change? Did the ability to pay change? Commonly, people get raises over that time. Kind of like child support, in terms of recalculating, say when the children 5, 6 years down the road, depending on how old they are for daycare, we're also going to need to go off then the incomes at that time. You agree?
I have some areas that I'm a little bit not in total agreement from that, because maybe this is a total long shot. If the divorce or family law were to impact whether or not inflation decreases, That would be
Alimony
a
could
whole
go down.
study by itself.
Right.
Now, whether or not someone debt to income ratio and whether or not they can afford their bills, we can define it as inflation or just day-to-day living.
Right.
That's my thought process of it.
Right. And thank you all for joining us today. My name is Jeffrey Smith. Again, I'm at the Waterford Lakes office.
And I'm Marsha Summersill. I'm at the Altamont Springs office. We also want to ask anyone with any questions or need any more information, feel free to call the law firm. Also, you can email us and we can assist you and get you through this process.